Welcome to Regulatory Ramblings. Our podcast is brought to you by the University of Hong Kong's RegTech Lab, the HKU SCF FinTech Academy, the Asia Global Institute, and the HKU edX Professional Certificate in FinTech, with support from the university's Faculty of Law. I'm your host, Ajay Shamdasani, and a very happy New Year to our listeners as this marks our first episode of 2025. In response to your feedback and in appreciation for your continued support as we going on our third year, we're trying something different this year. Moving forward, we're going to split each episode into two parts. We're going to do a short segment at the start of each episode featuring a thought leader or a topical and timely issue, followed by our standard long-form conversation. It's our aim to provide you with more information, insights, condensed into an hour. We know your time is precious, and we appreciate you spending it with us. But today, our first guest is analyst Ross Feingold. He'll be talking to us about the extraterritorial enforcement of U.S. laws and regulations under the Trump administration, including sanctions and trade tariffs, with an eye towards the Asia-Pacific. Following that, we'll be chatting with Ben Hammond, managing partner of law firm Ashurst's Hong Kong office, on the city's new Stablecoin Bill. Ben's a partner in the firm's financial services and regulatory group and leads its non-contentious regulatory practice in the territory, where he advises clients on a broad range of transactional and non-transactional regulatory areas. But first, Ross Feingold. Ross Feingold is a business development director at SafePro Group, a consultancy advising clients on security risks throughout the world. He's admitted to practice law in New York State and Washington, D.C. Ross was previously an in-house counsel at the Royal Bank of Scotland, Deutsche Bank, and J.P. Morgan. He's lived in Asia for over 20 years, and the quality of his spoken Mandarin is impeccable. It's an open question as to whether or not the Trump administration will increase legal and compliance costs for firms in Asia. With Donald Trump set to return to the White House on January 20th, many in this region are jittery to see how he'll handle his second time round to the Oval Office. In the run-up to last November's election, the president-elect threatened tariffs of 60% on Chinese goods. He has since followed up by saying he would issue the first of, quote-unquote, many executive orders, including a 10% tariff on Chinese exports. Worse still, President Trump threatened the BRICs nations that should they make any move to either undermine or dump the U.S. dollar for trade purposes, the action from his administration will be severe. It's terrific in that regard, then, that we have Ross Feingold. He's a lawyer, lecturer, political analyst, as well as the director of the Association of Americans Resident Overseas in Taipei. And back when he was still based in Hong Kong, he was the chairman of the Republicans Abroad Asia. He is one of the youngest old China hands that I know. And with that, Ross, thank you so much for joining us.
Thank you for having me, and Happy New Year to you and all your listeners.
Happy New Year. So what can we expect in Asia on the overseas enforcement front from the new administration?
I think we should expect some robust enforcement when it comes to the items that the Trump administration, and specifically President Trump, have a strong personal interest in. Just to take a step back, the extraterritorial enforcement of U.S. laws is nothing new, and it spans many different areas. Examples include the securities laws, laws regarding forced labor is something that we've read a lot about in recent years, specifically with regard to Xinjiang and the ban on goods from Xinjiang entering the United States, and other areas as well. So the concept of extraterritorial enforcement is not new. It could be a very powerful tool, and we've also seen it recently with regard to exports of high-tech manufacturing machinery or chips to China. So I think when it comes to the areas of interest to President Trump and his team, there will be robust enforcement. And what will be the areas of interest of Trump's team? Well, that's the big mystery.
You know, it had been pointed out that some Chinese firms were being extremely cunning and that they were exiting China and setting up factories in Vietnam, Cambodia, Laos, Thailand, as a way to get around U.S. tariffs and sanctions. And I mean, some in the U.S. are wise to that, but I mean, is that an effective strategy long term, or is the U.S. just going to clamp down on those countries as well?
Well, keeping in mind, regardless of what industry we might be talking about, industry tends to move faster than governments. So that's why we saw some Chinese companies diversify their manufacturing locations in order to avoid higher tariffs that were applied to made in Chinese goods, first under Trump and then maintained under President Biden. But I think eventually the US government will catch up to that, whether it's the executive branch, the White House, the U.S. Trade Representative, or the Commerce Department, or the Treasury Department, or Congress. So I think that you framed it correctly. Is it a good long-term strategy? The answer is probably no, even if it worked as a short-term strategy for the last 5 years.
How does one then appease the Trump administration? How does what's an effective negotiation strategy in dealing with such a strong-headed administration that's adamant about its goals and executing them?
Well, one of the ways that's easier said than done would be to move manufacturing to the United States. And we've seen that with some of the chip companies, most notably TSMC, which is building 3 fabs in Arizona, Samsung, which is building a fab in Texas, and there are other examples in the tech industry as well. So to please the Trump administration, the easiest way would be to build manufacturing in the United States. Again, that's easier said than done, and it's obviously not cost effective in many cases because of the higher cost structure in the United States. Another way would be to move manufacturing to countries that have a free trade agreement with the United States, but those are not necessarily low-cost destinations either. For example, Singapore has a free trade agreement with the United States, but the cost structure might be higher. Although, notwithstanding that, Singapore is still a location for a lot of mature semiconductor manufacturing, and periodically there's announcements of new investments, despite concerns about land scarcity or labor. But Singapore is still a place where mature semiconductor manufacturing is actually expanding. And there's always the Mexico option, which does have a trade agreement with the United States and Canada, but Trump is threatening to make some changes to that agreement, just like he made during his first term. And there's a review of the trade agreement with Mexico and Canada that's scheduled for 2026 anyway. So it remains to be seen whether or not Mexico is a long-term option.
That's right. That's right. I mean, I believe tariffs of 25% had been suggested by President Trump for Mexico and Canada. And I never thought the day would come where skilled labor wages in Mexico are competitive with those in mainland China. But I guess, when you've seen almost a stratospheric increase in the cost of wages in China since post 1980, perhaps it's not surprising.
But just a quick follow-up on that point. One
Yeah.
thing to keep in mind with the tech, especially with the tech industry and its moves into Mexico, I'm speaking from Taiwan, and one of the largest and most prominent Taiwan tech companies, Foxconn Honhai, they've been expanding their production lines for various kinds of products very rapidly in Mexico. But when they move into Mexico today versus moving into China many years ago, tech companies have the advantage of going into Mexico with a lot of automation from day one, as opposed to having to rejigger their production lines to add more automation and release some of the labor that they needed to have in the past. And that becomes a very sensitive issue when suddenly in China you're telling the authorities, I don't need as many employees as I had in the past. But when they go into Mexico now, they're going in with a lot of automation. So that does factor into their evaluation, even if wages in Mexico have approached wages in China.
And the other thing is, I mean, just anecdotally from some of the businessmen in Hong Kong that I've spoken to that have factories in China, that getting into China is easier than getting out. That the administrative roadblocks that they've faced in terms of trying to extricate themselves from China have been immense, and they're being told they have to pay more than they thought they were on the hook for in terms of severance payments, and understandably, Beijing doesn't want manufacturing to leave China, but it's a bit of a quandary, and I guess such is the price of doing business in China.
Well, certainly something in China's what I call its toolbox when they're dealing with foreign companies or Taiwan companies is they could do an audit. It could be a tax audit. It could be a labor policy audit. It could be environmental audit. And they could use all of those tools when companies are trying to exit as well. So yes, it can make exiting very difficult until you're actually able to release all your employees, close the facility, and most importantly, extract your cash.
Oh yeah, totally. To say nothing of the repatriation of funds. That they're facing a crunch when it comes to forex, and they certainly do not want greenbacks leaving China. We come to the topic of sanctions, and with the Ukraine war entering its third year, things heating up with Iran, it stands to reason we're going to expect more robust sanctions enforcement. But then there is a school of thought that says sanctions have already been ratcheted up to the nth degree. What more can the Trump administration do?
It seems in the sanctions space that there's always one more, or actually more than one, but there's always one more company or one more foreign government official. When I say foreign, I mean outside the US. There's always one more company or one more foreign official or many to sanction. And that's why we see from periodic announcements, they've added sanctions against a Russian company or a Russian oligarch. They've added sanctions against companies in China. They've added sanctions against additional companies from Iran or North Korea. So there's always more room to grow the list of sanctioned entities or individuals in foreign companies. So that's certainly one thing to keep in mind. And there's always additional things or additional behavior or additional goods that could be sanctioned as well. So actually I would say for the incoming Trump administration, if sanctions is within their toolbox, that there's always going to be something to sanction from countries that the United States has disagreements, to put it lightly, with.
Then we come to the issue of badgering, bullying the BRICs nations regarding the fate of the dollar. The greenback isn't going away. Even Saudi Arabia wants to be paid in dollars for the bulk of its oil shipments to China. I mean, is that whole concern? I mean, okay, it may be the case that some of the BRICS nations find it's more efficient to use their own currencies for a certain degree of bilateral trade. But is the whole topic of dropping the dollar and Trump threat? I mean, is that overblown? Is that just more raw meat to his base for domestic U.S. politics?
I think this is an issue that's not going to go away, but it would certainly take an enormous amount of flexibility by the governments and specifically by the companies involved to actually have a substantive move away from the dollar. So I don't think this issue is going away. I think we're periodically going to hear about it. And periodically we'll hear announcements that a group of countries, whether it's the BRICS or on a bilateral level, have agreed to enter into some kind of research project or some kind of pilot project where they're actually going to try and use either digital currencies or their own currencies to transact. I mean, we've seen in recent years the example where India wanted to pay with its own currency, not dollars, when buying Russian oil. And then Russia said, well, what are we going to do with all these rupees? You know, we have nowhere else to use them except to buy things from India. And there's not a lot of things that we want to buy from India at the moment. So this will continue to be an issue. There will probably be small steps in growth away from using the US dollar to settle international trade. But the vast amount of international trade will continue to be settled in the US dollar. So I think this is an issue that will be for discussion, not just during the Trump administration, but over the coming decades.
And it's worth noting that Moscow has been accumulating rupees since the Cold War, pre-1992, pre-collapse of the Soviet Union. They've been just piling them up, and no clear view as to what to do with them. And as you said, there's not much they want to buy from India. Thinking back to your past life, if you were an in-house or general counsel or compliance officer at a banking or financial institution or a multinational corporation in APAC, and you're looking ahead at the year to come and the regulatory landscape and the full panoply, the full plethora of tools at the Trump administration's disposal, all the levers that they could press, all the pain points that they can exert force on. What would be your main advice to someone like that sitting in their office in Hong Kong or Singapore, elsewhere in the region? But I'm mainly thinking about your major financial hubs in Asia. What would be your main advice to them in terms of preparing for what the next iteration of the Trump administration might dish out?
I think we would have to have robust internal systems in place to ensure that we're not doing business or facilitating transactions for sanctioned companies or individuals or anything that falls within the anti-money laundering space. And we know from past experience, just in the past 20 years, the long list of very large global banks that had to pay enormous settlements to U.S. regulators because they were still doing business with sanctioned individuals or sanctioned companies or facilitating transactions, which were basically money laundering transactions. Some of the largest banks in the world have paid billions of dollars in fines to the United States regulators. And every time they find themselves in this situation, they promise to do better, but then some of the institutions get caught a second time. And part of the reason is there's a lot of turnover in institutions. Often in the financial world, people frankly have short memories and they don't remember the last time that their own institution got involved in this kind of situation and found itself in trouble for money laundering violations or doing business with sanctioned entities. So it seems to be a recurring problem, and that financial institutions can never seem to have a sufficiently robust system. And a more recent example here in East Asia, we saw with the money laundering scandal that occurred in Singapore, of all places. We think of Singapore as a place with very strict laws and regulations, and yet banks were facilitating billions of dollars of transactions, which were basically money laundering. And the regulator ultimately caught up and was not too happy. So I think banks need to be very careful that they're not doing business with sanctioned entities or helping to launder money from that list of countries or the individuals or companies from those countries. And that includes Russia, North Korea, and anyone else who's on that blacklist.
So picking up on that, will that mean higher compliance costs and greater legal risk management compliance headcounts?
I think if you want to stay on the safe side, then definitely. And also, in addition to just having headcount in compliance or legal, you have to do internal training. And often there's some tension. The business people want to make money. They want to bring in new clients. They want to facilitate transactions. And sometimes there is an internal tension between, for the legal and compliance side, to be being business facilitators or being hindrance to business. But when it comes to this anti-money laundering space or doing business with sanctioned entities, again, I can't emphasize enough. We've seen many institutions get into serious trouble that costs them billions of dollars in fines. And it turns out to be a recurring problem. We can almost guarantee that in the next 4 or 5 years, there's going to be another major financial institution that will be fined by U.S. regulators for violating money laundering or sanctions rules.
Interesting to hear you say that. I mean, sanctions is really mushroomed and just grown into a field in its own right. I don't think, I mean, to the point that it's a specialization, it's a profession in its own right. I don't think it's just an adjunct of AML, anti-money laundering and counterterrorism financing anymore.
Yeah, you may very well be correct, especially with the growth in sanctioned individuals and sanctioned entities, whether that's Russia, North Korea, Iran, China. I mean, China would be a perfect example because the list of entities that the U.S. is saying you can't do business with from China keeps growing. And so that's a minefield just by itself. Again, I would say financial institutions can never have enough of sufficiently robust systems or individuals who know how to implement the applicable watch lists.
One last thing. The Trump administration has indicated, and then some have suggested that this last election was the election that crypto bought. The Trump administration has said that it's going to be friendly towards crypto, and that the U.S. should be the crypto hub of the world. What does that mean for Asia?
Well, that certainly means that I think U.S.-based platforms will be able to onboard clients from Asia. So we've seen a lot of back and forth between regulators and the platforms about whether or not they could have U.S. persons as clients, or whether they could only have foreign persons, whether or not they need to have firewalls between U.S. or global businesses. Some of those firewalls may go away, so it may make the United States more attractive as a place to run the business from, and then they could onboard what they want. They want to be able to onboard U.S. clients and Asian clients out of the same entities and not have as much firewalls in place. So that'll certainly be something to watch for. How the trading platforms are going to be able to sort of reorganize themselves internally. Maybe they won't need firewalls, and maybe their Asian clients can trade on the same platform as the U.S. clients, and that might have some implications, both positive and negative, for liquidity, for example, or other aspects of the relationship between the platforms and its clients.
As you said, the securities rules have always, the presumption has always been extraterritorial enforcement. That's been the view of the SEC. And so I was thinking of the analog to that as applied to crypto, given that the SEC, the agency that's spearheading crypto regulation in the U.S. So yeah, it'll be interesting to see what pans out. Any other predictions, prognostications for the coming year?
I think President Trump is going to be very focused on trade issues. He clearly has a passion for that. Other issues that exist in the business relationship or the political relationship between the United States and other countries, that might be left to Trump's team. But when it comes to trade and trade deficits, it's something that President Trump has a passion for. So I think we'll see some very quick movement from President Trump on trade-related issues.
Ross Feingold, thank you so much for your time.
Thank you.
And we'll be right back. Welcome back. Our podcast is brought to you by the University of Hong Kong's RegTech Lab, the HKU SCF FinTech Academy, the Asia Global Institute, and the HKU edX Professional Certificate in FinTech. For the second part of today's broadcast, we're going to be talking to Ben Hammond, managing partner at the law firm Ashurst in Hong Kong, about the city's new Stablecoin Bill. Hong Kong is getting closer to experiencing the many applications of stablecoins, from domestic payments to cross-border trade settlements. A bill covering the digital currency winds its way through the Legislative Council. It was gazetted on December 6th and had its first reading on December 18th. The government's proposed Stablecoins Bill is therefore closer to becoming law as the city moves to balance financial stability and consumer protection while advancing its virtual assets agenda. Stablecoins are digital assets issued by private entities that maintain a fixed value relative to a government-issued fiat currency or other reference rate. Generally, they've served as a bridge for transactions involving digital assets on blockchains, which can't directly interact with fiat currencies. Potential stablecoin uses could include automating incentives, rebates, or loyalty points in digital wallets like the Octopus program, or by using stablecoins' programmability or the ability to input rules and data in the blockchain. Additionally, stablecoins can provide access to new investment avenues like tokenized funds, which use the blockchain for sales and redemptions, where assets under management are expected to climb to about $600 billion in the next 7 years, from $2 billion at the end of 2024, according to a report from Aptos Labs, Boston Consulting Group, and Invesco. Again, today's guest, Ben Hammond, is also a partner at Ashurst's Financial Services Regulatory Group. He leads its non-contentious regulatory practice in the territory where he's based and advises clients on a broad range of transactional and non-transactional regulatory areas. With his extensive experience in digital economy matters, Ben has advised clients across a broad range of regulatory areas, most notably in February 2023 when he advised Goldman Sachs on the use of its tokenization platform, GSDAPTM, for the issuance of an 800 million Hong Kong dollar tokenized green bond for the Hong Kong government. It was the first tokenized green bond issued by a government globally. And in February of last year, Ben led a team supporting HSBC as the platform provider to the Hong Kong Monetary Authority, the city's banking regulator and de facto central bank, on the world's first multi-currency digital native bond offering. And with that, Ben, Happy New Year and thank you for joining us.
Happy New Year, AJ. Thank you for inviting me to join your podcast.
Exciting times with the new bill. But first, tell us a little bit about yourself, where you're from, where'd you grow up, what your professional background, how'd you end up on the path you're on?
Yeah, thanks. So I'm obviously a solicitor, and I've been a solicitor here in Hong Kong for just coming on 10 years. And before that, I was 10 years practicing law in London. That's where I grew up. I grew up in southwest London near Wimbledon, and it's a rather boring individual, really. I had two jobs in my life. First with my firm in London, and now with Ashurst in Hong Kong. And I started off as a tax lawyer, but I soon saw the light when the financial crisis came along in 2008, and that's the point at which I became a regulatory lawyer, and that's what brings me here to Hong Kong.
Certainly no shortage of work in that domain post 2008.
Absolutely not.
What got you interested? I mean, you're knowledgeable on digital matters pertaining to the digital economy, but what got you interested in crypto? How did you segue into that little niche, which is in and of itself specialization even amongst regulatory lawyers?
And pretty diverse range of areas as well. I guess my entry into it really it's twofold. One is that when I look at what's going on in financial services, look at the way it's evolving, seems to me that the new technology, the use, the application of technology, means that really the global economy, the global financial pipes are being replumbed. Use this to mix the metaphors being rewired. And so really, in order to be able to be a regulatory lawyer, to advise the clients that I and Ashurst advise, whether that's banks or brokers or whatever sort of area of the market our clients are acting in, one's really got to understand the nature of both the assets which they want to hold and interact with, the assets and the transactions their clients want to be doing, and also, frankly, if people want legal services, they want to be getting advice on things they don't know. And so this is a sort of rather interesting and new area that, many of our clients themselves don't have that sort of, full expertise on because it is new to them. It seems to me that that's kind of what led me into it, I suppose, that demand for it. But I think what I find fundamentally most rewarding around it is that it is an area that really is challenging the very sort of basis of many concepts of law, and by which I mean that really at the heart of most questions, it seems to me, around digital assets, virtual assets, crypto, however one wants to describe them, as a sort of broad sort of range of digitally driven asset classes, is the fundamental questions of what is property and law. I mean, we've grown up, and certainly I grew up at law school knowing that there were two types of property in common law, in English law, in Hong Kong law, things in possession and things in action. And it turns out that with these new digital assets, increasingly we're thinking about a third category, and there's been quite a lot of work done by governments, by academics thinking about that. And wherever that lands, I suppose what's most interesting to me, I think, is that that's really sort of black letter fundamental questions of law, but being, sort of fundamental to real life questions, real life advice, and real life transactions that our clients are doing. And maybe just one point on that. It's a pretty variegated landscape. Yes, there's crypto. I mean, I think many people would also draw a distinction between sort of traditional types of assets, which are being registered, transferred, held on distributed ledger technology or other kinds of blockchain technology. And I suppose digitally native assets, maybe of the nature of something like, Bitcoin, Ether, those kind, which are, as it were, children of, the digital, this digital technology itself. And so on one hand, what you've got, I think, when I talk about sort of replumbing, you've got bonds. You mentioned a couple of jobs we've done recently. We're very lucky to do with our clients. Traditional bonds, but using technology. But then, of course, you've got a whole range of other types of virtual assets, which wouldn't be there but for those, the new technology. And so you end up with not only traditional markets being rewired and replumbed, but we've got new markets being invented. And so I think in the end, that's what's led me into this, the demand from our clients. But fundamentally, I just think it's a really, really interesting area to be involved in.
Clearly, it's an emerging field. It's a nascent area. The contours are still being shaped. The parameters are still being influenced. And I guess it's an exciting time to jump in because the gap between, because it's in its early nascent stages, the gap between someone who doesn't know anything and the gap between a so-called expert is not that great. It doesn't take you all that much to bone up on the subject and market oneself as an expert. And I don't mean that as a dig, but when I look at the lawyers practicing in this space, they tend to be transactional lawyers. They tend to be regulatory specialists like yourself. They tend to be dispute resolution lawyers who have a client who had a dispute in cyberspace and Web3, fintech, pertaining to crypto. And they became experts, the hard way, through on-the-job training, through trial and error, learning from their mistakes by studying their clients, and given that most lawyers in this space are not techies, generally speaking, my question is, what value do lawyers add in this space, given it's so technical in nature? And is it the case that many lawyers will ultimately end up having to defer to the judgment of or consult those that are tech savvy as they advise their clients? In a sense, the client is getting advice not just on law, but the underlying tech. It's hard to avoid the technology issues inherent therein. And again, what you were saying about creating a third category of property, tangible versus intangible property. I mean, yeah, it seems like it could very well lead to a reimagining of the law.
It's an interesting question, Ajay. I mean, I don't take that as a dig. I mean, I think it's a very valid question, in terms of what the value that, lawyers can offer. I mean, I suppose though, in the end, and Stablecoins Bill and in due course the ordinance, good example of that, is that the way in which I suppose we regulate ourselves as a jurisdiction, the way the common law works. I suppose there's a couple of points which are relevant to this. First is that maybe common law is a sort of process of trial and error. I mean, instead, common law is the result of precedent. It's the result of judgments from judges in courtrooms hearing the facts of cases and applying legal principles, and thus expanding, as it were, one's understanding of the law and ability to apply it. So that trial and error, it seems to me, is very much the heart of that. And then the question of, well, do we defer to technologists? I mean, I think it's an interesting question, because you're absolutely right that, you asked me about my background earlier. I didn't say I did an English degree. I certainly didn't do a degree in an English literature degree. I didn't do a degree in anything, I suppose, specifically relevant to the technology underlying this. And yet at the same time, if the technology cannot be understood by someone like myself, someone who is not, an expert in the underlying technology from a technology perspective, are we comfortable with that? I think the nature of the way in which we mediate between those who are experts in it, those who, dare I say, also are selling the technology, and those who are the users of it, who don't necessarily have that expertise, but still need to be protected. And all those other participants in the economy who, again, won't understand it necessarily, but need to be protected. If one can't reduce the technology to language which people understand and which can be understood, and therefore where people have disputes can be resolved, that strikes me as quite dangerous. And so in some ways, I think things need to be explained. They need to be defined. They need to be understood so that we can all take a position on that and orient ourselves around it. I mean, and I guess the other point I'd make is that it is certainly true that the technology is extremely novel, and it is altering what we understand is possible through technology. And yet at the same time, I suppose was the sort of biblical saying, isn't it? Nothing new under the sun. In 1935, the Hong Kong government
Everything's a variation of a theme. Yeah.
Well, it is. I was going to say in 1935, the Hong Kong government brought in the currency ordinance. And before that, note issuing banks were issuing, currency, as it were, in exchange for deposited silver. The law about private mediums of exchange was what we're talking about with stablecoin. There is law for that. The law has thought about this. A case law does exist around these issues, and so I think that's what's important. Is that also when we're told something is entirely new, sometimes it's not as new as people think it is. It's a novel application of human ingenuity. But I think we can also learn lessons from the past. And coming back to the point, I think if common law lawyers like myself are, as it were, the interpreters of past errors, and the judgments that have come from that, I think it's important to know history to avoid the mistakes in the future, and therefore understanding that past context, bringing that to bear, and putting that together with technologists is quite a powerful tool for preventing things going wrong, rather than just hoping.
I guess they call it the practice of law because you do it until you get it right. Until
I won't take that one as a slight either, age.
No, but I mean, the common law lawyer is first and foremost a proceduralist. Procedure matters more, perhaps, in the common law than the civil law world. But I do think because of its adaptability, because of its malleability, because it's more business friendly, that the common law certainly has an edge in this regard. But I guess we're all products of environment. I'm showing my own bias here, but yeah. So in terms of what we have to look forward to, what can we expect from the new stablecoin bill? And I mean, why is it important? How will it move the industry and the overall economy forward?
I think it's been trailed for a little bit of time. It completes the sort of patchwork of regulation which is being brought in to sort of cover that digital assets, virtual assets, crypto landscape. We had the virtual asset service provider regime coming in over the last year or so, and from July 2023, and then obviously there's been a transitional period for the implementation of that, and that sort of referenced space around stablecoins, regulated stablecoins not being called a virtual asset, and so that has paved the way for this, which gives us our first sort of area of regulated stablecoins. So in that sense, I suppose it's completing a patchwork of legislation covering what previously was or could be unregulated. Covered this a few years ago, and frankly, unless you could, look at a particular digital asset and say, okay, that is an equity or a bond, or it's got those kind of bond-like or equity-like features, or fund-like features, or cash-like features, and then you sort of by analogy said, okay, this is the area of regulation that regulates the analogy. You didn't really have anything specifically on point. So what we've got now is specifically directed stablecoin legislation. And I think the importance of it is there's a number of things apart from just sort of for the sake of it, filling in the gaps. I mean, the first is that Hong Kong is looking to, of course it is, and you mentioned about vested interests. I certainly have one in this as well, but it's maintaining its position as a global financial center. And importantly, if global financial markets are using stablecoin, or at least need the frameworks for it, it is important that Hong Kong provides that. To extend the analogy, I was using of plumbing earlier. If you need to be plumbed into the global financial economy, you need to have the pipes through which the economy can run. And so it's important we have that. The second point, I suppose, is by defining what is regulated or can be regulated, it also creates a bit of space from that which is kind of pushed out and can then for either be restricted or proscribed. So, one of the areas here is to be clear is this is regulating fiat referencing stable coins. So these are stable coins maintaining a stable value against currency or specific currencies rather than, and through, the holding of the assets themselves to back them rather than, which has been quite, well covered in the news, some of the more sort of algorithmically purported stable coins. So that's one other area it creates that distinction. And then I guess the last and most sort of practical one is there is currently a sandbox with 3 stable coin projects being evaluated by the MA, and this also gives them somewhere to go when they come out of it into a regulated world in which there is legitimacy and confidence around the use of it, which in the end, if a stable coin is to be used as a kind of form of, as it were, private money or medium of exchange, confidence and legitimacy are sort of vital to them really being able to be used. So I think as I say, I think it's important systemically. It's filling in a gap, but it's also creating legitimacy and creating a sort of bit of a platform on which to build.
I guess the next thing that pops into my head is, why did it take so long? Or is it the case that the slow, deliberative approach is to be expected by established jurisdictions that have, deeply rooted legal systems like Hong Kong and Singapore, whereas Dubai, where I'm at right now, they can overnight by royal fiat say this is how it's going to be, and so it is done. I mean, when one thinks about how quickly they created VARA, the world's first virtual asset regulatory authority, of course, then that's leading to claims that they've perhaps been too acquiescent, too accommodating to the industry, that they've bent over backwards too much, and the 2008 certainly taught us self-regulation is as good as no regulation at all, and certainly in the minds of many. So is there a reason to that slow, deliberative process with Hong Kong, or is that just a quirk or an aspect of the system we have to accept that's the system we have because we don't jump on the bandwagon easily? We think through things and then we act.
It's an interesting question, AJ, because I suppose on the one hand, actually, you might look at this and say, gosh, it's actually moved very quickly. I mean, you're right. I mean, others have created frameworks more swiftly. And we know when one looks at other jurisdictions, you can also see jurisdictions that are a lot more unified, maybe because there is a single regulator and, really they're just plugging in sort of additional rules sitting under their framework to cover a new asset class, but the same regulator. Whereas we'll see in Hong Kong, we've got a number of regulators, the SFC, the Securities and Futures Commission, regulating virtual asset service providers. And so therefore many virtual assets. You've also now got the monetary authority, the Hong Kong Monetary Authority here in relation to stable coins. So and that's, a feature of the Hong Kong landscape. So you've maybe got more stakeholders there. But yes, I mean, I suppose it's also the nature of a common law system in which law is made not not by any single group or individual, but by a process that it needs to go through. I mean, if you look back over this, I mean, I suppose the Financial Stability Board, at a global level, they published their final paper around stablecoin, the recommendations, only in July 2023. And that was around the same time the virtual asset service provider regime was coming in. It was the end of 2023 that the consultations on this, now the bill, started. They were finished up in the summer, and we've got the bill by the end of this year. So, I mean, on another measure, I think you could say, so actually it's only taken a year and a half since the FSB's recommendation. So I suppose maybe in the grand scheme of things, if this is a big change and a long-term change, what is a year or two in the grand scheme of things, I suppose.
Yes, because it's still early days. People have likened this to the early days of the internet. So, okay,
Yes.
Stablecoin bill will pass. Everyone expects it to. It will add another component to the city's growing body of financial law. And the expectation is it will mean adding to the regulatory compliance burdens that legal and compliance staff at banking and financial institutions have to deal with, should they choose to deal in such instruments. What will it mean from a compliance perspective? Will it mean more compliance expense? Will it mean greater headcounts as people seek to recruit more crypto compliance experts? What are your expectations?
I was sort of thinking about this question as you were asking it. I mean, I think the most impacted are likely to be those who are currently unregulated, who need to become regulated or frankly close their business if they don't go into the transitional regime. They will need to, if they're going to get licensed as a issuer of, or want to become a licensed issuer of stablecoin in Hong Kong, doubtless they will need to recruit. And actually, when one looks at the virtual asset service provider regime, and when that was brought in recently, there was a bit of a squeeze really on expertise there. Those that have that sort of nexus expertise between the technology and the regulatory system. I think for many already regulated market participants, whether or not they're SFC licensed corporations or authorized institutions, banks, actually I'm query the degree of sort of increase of imposition here for two reasons. The first is that actually for some time now, the Monetary Authority and the SFC have been quite focused on any kind of sort of virtual asset exposure in institutions. And so already, even where they haven't been regulated, many of our clients have already been really put to task to engage with these assets where they are. And so they've got pretty well developed, where they are engaged with them, pretty well developed infrastructures and internal expertise to handle it, or at least developing already. And I would query whether or not this will itself provide much of a incremental increase in that. I think the other point though to make is that stablecoin is itself a sort of, in this concept as viewed in the bill and what's being facilitated here, is a payment method to engage with other assets and other services. And so unlike, as it were, whether one wants to hold, let's say, Bitcoin or a tokenized bond, where there might be a sort of question of whether or not your clients want that, actually for those that are already involved in the virtual asset space, actually being able to facilitate stablecoin, the holding of it, the using of it, is probably quite important. And so actually, I think this will sit alongside many of the payment methods which institutions already provide. And so this is more about, I think, facilitating engagement with digital assets. And therefore, there's a little less optionality around it, I'd suggest, for those that really want to engage in that virtual asset space. Because, where this is really important is it's creating a digital payment method to buy, amongst other things, digital assets to create that delivery versus payment immediacy. And so really, unless you can do that as a sort of business proposition, I think there's a risk of being left behind around this. So I would have thought not a massive regulatory uplift, but doubtless, there will need to be policies put in place. And yes, there will be plenty of room, I'm sure, for lawyers and advisors. But I think there's also a sort of commercial proposition here that many will be looking at, and we'll see it as justifying itself.
So if I understand you correctly, focus more on the apparatus rather than the instrument itself.
In terms of the investments that are required, I think, but as I say, I think those that are going to be most impacted by this are those that are unregulated currently, and there will need to be regulation brought in, and also those who are sitting offshore wanting to offer instruments into Hong Kong, potentially having to establish a presence in Hong Kong. So I think there'll be quite a lot of thought, but I don't think this will come as a surprise to many. I think this has been trailed for some time, and as I said, I think the opportunities here are pretty great.
Yeah, that is the hope. And in terms of the compliance people I've spoken to, it should not be construed as compliance in the digital or crypto age is altogether all that different. I mean, these are bridges that can be crossed through a certain amount of remedial in-house education or training. So it is not the case that all the skills and all the knowledge that they've gained up until now are useless, and this is a new age with its own rules. Because again, everything is a variation on the theme. In the time we've got left, is there anything you'd like to add? Any remaining impressions you'd like to leave our listeners with?
I think the only comment I make is that the firm I work with, I'm lucky to work with, is doing a lot of work in this space, and so we're seeing a big snapshot of what's going on globally as well as here in Hong Kong. We've got a global practice, and my colleagues sit as much in London as they do in Hong Kong in this space, because as you made the point earlier, AJ, the technology itself is so fundamental to this, and that itself is not bound by any particular legal system. But I think what's really exciting about this area, I think what's really interesting, and where we as a firm can add a lot of value, is bringing those perspectives from other jurisdictions to Hong Kong. And so, I think depending on who is listening to this podcast, whether you're a sort of user of these instruments or whether you're a student thinking about it, I think there's a lot to be learned from what's going on in other jurisdictions at the moment. Whether that's the Law Commission in England, Wales, and their review of digital assets, whether or not that's what's going on in places like Singapore, or indeed, as you mentioned, in Dubai. And I think it's a really interesting area of law, because we bemoan in regulation a lot, I think, a lack of joined upness. It's a terrible word, but between different jurisdictions in regulation. But actually, this is an area where, yes, there is an element of individual jurisdictions making their own rules. Yes, there is. But at the same time, a lot of these rules are being made for the first time, and there's a real opportunity here to make things work a bit more smoothly cross-border. But then you look ahead the next year, and this is well beyond my pay grade, be interesting to see what happens in the US in particular with the changes there, and how that drives regulatory and frankly interest, and the use of these assets and these asset classes within our clients, financial institutions globally over the next 4 years with the new administration in the US. So something to watch there in particular.
Your point about the lack of connectivity between different jurisdictions and between the legal profession in different jurisdictions is well taken. Certainly, my sense is that, and I remember researching this for a book for the Law Society of Hong Kong back in 2007 for their centennial, that since the 70s, the trend globally has been towards a more globalized legal profession. One academic here at HKU told me that he sees things like fintech and crypto and the underlying technology actually contributing more towards the globalization of the legal profession as well, because as you said, the technology is global, and the practitioners in this space necessarily they have to practice globally across jurisdictions. Is that overstating the case, or is there some truth to that?
So look, I think there's a lot of truth to that. I think, and I see that day to day, which is that in my sort of day to day practice in the sort of digital asset space, I'm as likely to be reading a sort of New Zealand, Singapore, Australian, English bit of case law as I am to be reading Hong Kong case law. Whereas I suppose in the more traditional financial world, because things are more settled, and you tend to look more at the national case law and the legislation. So I think there's a lot more cross-fertilization across the common law world in particular. I'm less able to speak in that sort of civil tradition. Within the common law world, I think lawyers dealing with space day to day are dealing and reading into the law of many more common law jurisdictions and taking inspiration from that, as are the courts. And so I think it does seem that it is a catalyst this area and the law developing around it for that. Difficult to know. Globalization may be. I mean, we've certainly got national legal systems and views aren't always aligned on these issues, but at the very least, there is a sort of global conversation going rather than individual jurisdictions looking at this in isolation and thinking about what they want to do without, as it were, taking a very specific view on how other jurisdictions are looking at it and how this would be viewed by other jurisdictions. I mean, if you look at the financial institutions in Hong Kong, enormous number of them, whether because they're branches or just because they sit within international groups, it is very important that what they're doing here and how it is viewed when it rolls up into their group is compatible. And so Hong Kong as an international financial jurisdiction, financial hub, I think has at the forefront of its mind also making sure that it doesn't give issues to those who are legitimately engaging within the market, so that things are viewed in Hong Kong appropriately can also be appropriately viewed in Paris, in Berlin, in London, in Sydney, wherever that might be.
Ben Hammond, thank you so much for your time.
Thank you very much, Ajay.
And to our listeners, thank you. Till next time, and all the best for the coming year.